We actually would move for a continuance because we need to go through all the 1,000 pages again and figure out what portions should be let in. If the court's not inclined to let all of it in, then we don't have anyone in the cry room doing this for us. So we need time to do that. So we'd ask for a 2-day continuance.
It's day 11,952, day 11 of the Kouri Richins trial, Utah versus Kouri Richins. We seem to be getting very close to the end of the state's case in chief. But you know what we haven't heard? All the stuff Kouri Richins said to law enforcement. We haven't heard any of that yet. There's a lot of stuff that Kouri Richins said to law enforcement. There's a lot of stuff that she wrote down. There's a lot of stuff that she said. There's interviews. There's jail calls. There's a lot. Remember, at the end of the day yesterday, the court said that the lawyers were coming back in an hour before the jury to work on what was being redacted, unredacted, what completeness, what was coming in. And this is a big deal for both sides because, again, the prosecution's using Kouri Richins' words against her, and the defense can't introduce Kouri Richins' own statements to benefit her, but they can ask for completeness. So we are going to watch the lawyers until they're done. How long will that be? I don't know. They're still going. So they gave themselves an hour. They're still doing it. It's March 10th. It's Tuesday. We got a lot to do today, and the lawyers are trying to figure out what's going on with the judge. I'm curious to see what happens.
So, Your Honor, in questioning Jeff O'Driscoll today, I will ask him about conduct of the interview of Carmen Lauber. Ask him about the defense's question. He was present when the defense questioned Carmen Lauber about certain statements. In context, do those are those statements, fair? No. And then move to admit the various 57 through 60, whatever.
Do you have these as one kind of video clip that plays from interview to interview, or will you provide some signposts for the jury as you introduce them?
Your Honor, we don't intend to publish them. We intend to make a few points from them through Detective O'Driscoll's testimony, provide them to the jury, and in argument argue something like, you heard the defense cross-examine Carmen Lauber. You heard Detective O'Driscoll's testimony regarding those interviews. You have them before you if you want to, or you have these excerpts before you if you want to dig through them and determine for yourself what the evidence proves.
It really comes back to the issue of whether these transcripts go into the jury room.
Just play the
Publishing,
video.
You're right. You have the right to publish them to the extent you want to. I am not persuaded sitting here right now that they go into the jury room. So we don't have to necessarily reach agreement on that piece right now, but how do you want to proceed with Detective O'Driscoll on recognizing that they may not go into the jury room?
Well, then you need to play the videos.
Your Honor, that would...
You need to play the videos on. And
alter
the transcripts need to be on the videos.
Detective O'Driscoll, because we would end up publishing 100 pages of transcripts.
You have them as video or audio, though, too, right?
Well, right now, we only have the transcript.
Oh.
We were waiting. Video editing is long and expensive.
I see.
And so we were waiting to nail down the transcript to then conform the video.
Is audio easier? Do you have audio files?
What did
Ms. Shermack is saying no.
It's the video file is the audio file.
The same.
It's one.
I see.
So there's no distinction in terms of editing time between a video and an audio file.
These are being offered as prior consistent statements of Carmen Lauber to rebut a charge of either recent fabrication or undue influence.
Correct.
I understand.
So, any objection
Agreed.
under that rule?
Yes, that should have come in under Carmen. During cross-examination, it's fully within our right to pick out portions of this interview.
But you can recall her, right?
I don't think that's our job to recall.
No,
this
they can
star
recall
witness.
her.
They had her on the stand.
I just asked you a yes or no question. Would you start there?
She's like, no.
Could we recall her? Yes, that is something that could be.
Then it's not a
possibly
Crawford problem.
done. I don't imagine what world the defense would do that. But
And correct me if I'm wrong, you had the transcripts when you cross-examined her, right?
yes,
Yes.
but so did they. And
We've
the
covered
appropriate way
this.
to do it
They did this
would have been to try
yesterday.
and rehabilitate her on redirect, which would have then given me a chance to go into other statements.
They sought
During
to,
cross.
and I limited their ability to put in the whole 900 pages.
That's not how you rehabilitate. You rehabilitate by asking questions. It's not by putting in an entire transcript. Instead of doing the hard work to try and ask her questions, they just want to put it all in. And they want to cherry pick what they wanted her to say, which clearly would have been very difficult to get her to say. So the easy way is here. We're just going to hand you the transcripts that show you what we wanted Carmen Lauber to tell you, but instead, here, just read it.
I don't think that's-
Without putting in the whole story or giving me a chance to.
They wanted to put in the whole 900 pages. That's where we started. We started with them wanting to put in the whole 900 pages and then narrowing.
Go back and cross-examine her. And I think requesting us to recall her is burden shifting. That is not what our job is. That's
I
not what
don't
we need
think
to do.
that's what
They needed to
happened.
take care of their witness when their witness was on the stand.
They can do it this way too, though. They're allowed to. They're allowed to bring in
Remind
these
me,
interviews.
You objected to the addition of any part of the transcript at the time they offered
Yes, she
it.
For the
did.
same reason. They offered it after she was off the stand.
Had they offered it the 900 pages when she was on the stand, you would have said okay.
No, she wouldn't have.
No, I would have said you need to cross-examine her, redirect her and rehabilitate her testimony.
And so how do you see the rule regarding prior consistent statements working?
They need to get it through her. They could have put on
But
prior
you-
That's not the
consistent
rule.
statements through her.
I
And then
really don't understand. You're saying that prior consistent statements never come in. You only can ask questions. Please help me understand.
I don't understand. I'm sorry, Your Honor. I really am not following what you're trying to say. I have never seen this done any other way than through a witness. That's why we have witnesses. If not, why have any witnesses? Let's just hand the jury all the evidence. Let's hand them all the transcripts of
Well, no, be fair to how the rule works. Somebody testifies on cross-examination. Defendant makes a charge of recent fabrication. And then
Right.
the proffering party has an opportunity to offer prior consistent statements to rebut the charge of
Right.
recent fabrication. There is no authority for the proposition that prior inconsistent or prior consistent statements can only come in through the declarant witness as long as the declarant witness testified and was subject to cross-examination.
Right.
Indeed, it is defendant's cross-examination of Ms. Lauber
That caused this issue.
creates the foundation for admission of prior inconsistent statements based upon Ms. Lauber having not remembered or having forgotten, though that's not what the state is seeking to do here,
Right.
and prior consistent statements based upon an express or implied charge that Ms.
Recently
Lauber was
fabricated
acting
statement.
from a recent improper influence or motive, to wit, pressure applied by, among
enforcement.
others, Detective O'Driscoll, the U.S. Attorney's Office, agencies like that.
That's exactly what
There is
they
not
charged.
a Crawford problem here. I still have some concern that given the volume of testimony that the jury hears, the only transcripts they would have in the jury room being this 100-ish pages of Carmen Lauber would attract
It would be
some
weird.
unwanted attention on appellate review.
Remember, we have talked about this in other trials. Don't be weird. When there is one thing that is not like the other, it tends to stick out more than the others. So if everything else is going back in the form of a video or audio, just sending these back as paper is weird. It's the one thing that does not fit. I understand the court's position on that, which means the prosecution is going to have to then edit the video, I guess.
Why can't the state just ask Jeff O'Driscoll a bunch of questions about
They
whether
can.
certain exchanges with Ms. Lauber occurred? And to the extent he doesn't remember or can't remember specifically, use the transcripts to refresh his recollection and even show the jury, publish them at that time, but use him as the root. And if you want to call Ms. Lauber, you're entitled to do so.
Your Honor, that may be the route anyway, and it may just, from an efficiency standpoint, going through the questioning to ultimately get to refreshing and publishing, it seems to me that that's what's time. It will be more efficient to just publish the 100 pages.
Okay.
Because that's where we're going to land anyway.
If those 100 pages are going to be published, we want all of it published. We want all 1,000 pages.
All right. And how do you want?
The judge is just blinking. The judge is just blinking his eyes. He's like, okay, you want all 900 pages then?
The least prejudicial way for us to do it is to send the recordings, all 7.5 hours, into the jury room and allow counsel to make arguments about what they show and what the jury should take from them. You could do that by stipulation.
No, I don't want to do that. I think that even though it's not efficient, the appropriate way is if any of the
And the defense
interviews
is
are going
like,
to be published,
mount up
they
and
all
ride.
need to be published.
Publish them all in court.
Only published.
Correct.
All right.
Well, if they get
I
published,
appreciate
then they
your
go
position.
back.
Mr. Bloodworth, take it from there.
The state is fine with sending full videos back, or some mix of publish the narrow pages and send a full video back.
They don't have to publish all 7
but-
hours.
The notion of publishing nearly 10 hours of
Video is silly.
interview is, I don't think it's productive. I think it's a waste of the jury's time.
That's what the defense wants.
I think the jury needs to see
No, you don't.
exactly what her demeanor is, how she acts with the officers, how the officers treat her.
Need and want are not the same.
There are numerous other parts of this transcript that may come in through Detective O'Driscoll. I don't know yet. I mean, I don't know the answer to that fully yet, but there are a lot of other statements by both Detectives O'Driscoll and Detective Maynard that go to show that she was unduly influenced.
Then what portions are those? What the court would like you to say is there are numerous portions of these videos. We want this portion, this portion, this portion, this portion. The all is the problem. You've got to narrow down the parts you're asking for. That's what he's asking you for.
I don't have specific outlines right now in the 1,000 pages of transcripts as to what we would want and what
This
we would.
issue started last
I mean, we want
week.
all of it. If you want me to go through all 1,000 pages again and try and figure that out, I mean, guess we can find some time to do that, but.
Okay. So, Mr.
Oh, my
Bloodworth,
God,
as
I
for
can't-
today, how does the state propose to proceed?
The jury is still out. And the judge is just like, what are we doing?
So I propose we call Chris Cotodemos. I then will call Jeff O'Driscoll. We will get to maybe, 45 minutes into his argument before this will become an issue.
The issue before the court is the state's motion to admit redacted exhibits 8-57R through 8-63R. The state is offering what it views as narrowly tailored portions of the transcripts of Ms. Lauber's prior interviews with law enforcement investigators and other government agencies as evidence of prior consistent statements by Ms. Lauber under 801D1B to rebut an express or implied charge that when she testified in open court in this case, she acted from a recent improper influence or motive in so testifying.
Right. The court has ruled that
In
this can come
response,
in,
defendant
it's just how.
does not provide a sufficiently specific argument that the state has over-designated any of these portions beyond what would be permissible under 801D1B.
that.
And though defendant makes a Rule 106 argument, regarding additional portions that would be necessary to provide context for, explain, or qualify Ms. Lauber's statements. Their position is that all of it does, and that does not provide the court with a sufficient basis to rule one way or another whether other additional
Are you going to give them more
portions of
time?
these prior interviews are required to be included under Rule 106. Based on the record currently before the court and the procedural posture that brings us to this point, the state's motion to admit redact exhibits 8-57R through 8-63R is granted to the following extent. The state may publish these exhibits and use them with witnesses that are on the stand. Sitting here today, the court is not prepared to rule and does not rule that 8-57R through 8-63R may go into the jury room as admitted exhibits under Rule 17K because, sitting here at the moment, the court determines that they should not, in the opinion of the court, be in the possession of the jury to make absolutely sure that the jury does not give undue influence to these specific portions of a single witness's testimony as compared to the testimony of all the other witnesses.
So he's reserving ruling on that.
We actually would move for a continuance because we need to go through all the 1,000 pages again and figure out what portions should be let in. If the court's not inclined to let all of it in, then we don't have anyone in the cry room doing this for us. So we need time to do that. So we'd ask for a 2-day continuance.
Your request for a 2-day continuance is denied. I don't have a basis to use that much time of the jury when this motion was filed 2 days ago and I raised it with you yesterday morning.
All right, a 1-day continuance then?
To tomorrow morning.
Yes.
And what is it you're going to do between now and then?
I guess we're going to go through the whole transcript and find out what we want included under Rule 106.
And you're going to file something so I can read it?
Yeah.
That request is granted. We need to come up with a set of deadlines by which defendant will take those positions in writing, by which the court and the state can review them.
Oh my God.
By which we can have a discussion on the record about which of defendant's positions are persuasive. And if possible, Mr. Bloodworth, and I know I don't have any control over this, I'd really like to build in time for the state's video editor to take whatever I decide and turn it into a video so that when we're publishing a video, not just pages of a transcript.
Was the court considering a deadline from defense, something like
That would
6
help.
p.m. today?
Yes, something like that.
If we get that at 6 p.m., my sense is by 8:30 tomorrow, the state will have a response. The court rules by
9:30.
9:30. We can probably get the video done.
Okay.
I don't think we can get it done by 6.
I don't understand why.
So what
I mean,
the fuck?
The transcript is only this much stuff printed in.
I can't even believe that the court is entertaining this at all. But the court has been incredibly accommodating to defense.
So 6 p.m., we need it in writing, filed in the case, please. If you would separate out what you believe need to be de-designated versus what you need to be, I think needs to be added under Rule 106, I'd appreciate that. We'll reconvene at 8:30 tomorrow morning. Yes, Mr. Bloodworth?
Yes, sir.
And then we'll invite the jury to come back at 1 p.m. tomorrow.
Oh,
Does that sound reasonable?
Yes, sir.
Oh boy.
Okay. Very good.
The beginning of the day started with the lawyers coming back at 8:30, the jury coming back at 9:30, to prepare for Detective O'Driscoll's testimony. Detective O'Driscoll is likely the last, if not the last significant witness for the state. They might have another witness or two tying up loose ends like Kostrodemus. They might not. But the last significant witness for the state. Through O'Driscoll, we're going to see Kouri Richins' interview, the jail calls, the walk the dog letter, and the rest of it. So they were going through and fine-tuning what was in, what was out, what was going to be redacted, what might be unredacted, based on how the evidence has developed so far. And you saw the attorneys on both sides at some point say, yeah, we withdraw that. No, we would like that redacted. No, we would like this unredacted. And then, after all of that happened very normally, we got to Carmen Lauber. And when we got to Carmen Lauber, we got to a wild, disjointed, circular argument that has happened in the days before. And it was very similar to the arguments that we saw regarding Robert Crozier. So we are now deep into the rules of evidence. And the prosecution said, Your Honor, since the defense brought up in cross that Carmen Lauber had recently fabricated statements, was motivated to fabricate statements, and had made prior inconsistent statements, we are allowed to rehabilitate that witness with prior consistent statements and show some of her interviews. The prosecution narrowed down the 900 pages of transcripts to 100 pages of transcripts. And the court had previously ruled with Crozier and indicated with Lauber that can come in. The defense previously argued that has to come in through a witness. You remember these arguments with Robert Crozier. These has to come in through a witness. And the prosecution's like, no, we're just going to play the video. We're just going to just roll that video that doesn't need to come in through a witness. Because you had the videos and because you had the opportunity to cross-examine Robert Crozier, we're just going to roll it. And that's what they did. And that's the same position we're in with Lauber, except the prosecution said, well, we have a transcript and we want to be able to send the transcript back with the jury. And the court's like, I don't love sending the transcript back with the jury. Are there other options? And the prosecution's like, editing down these videos without a court ruling is going to take a ton of time. It's like 7+ hours of video. We need a ruling so we're not redacting, unredacting the video. We don't want to cut and then recut video. It takes time. So the defense argued again that Carmen Lauber has to take the stand for the prior statements to be allowed in. And that went round and round and round for a moment. And the court said, no. We're not doing this again. You do not have to have the witness on the stand who is the declarant, the one who said it, in order to admit these. It can be done with O'Driscoll. The defense raised cross-examination, confrontation issues, Crawford issues, and said, Your Honor, no. The court pointed out, as the court did previously, you had all these interviews before you cross-examined Carmen Lauber. You were not restricted in any way. The court pointed out more than once today that the reason this is coming up is because of the choices made in cross-examination. You chose to cross-examine this way, now this comes in. If you had not gone there and cross, this would not be coming up. You made a choice. The prosecution is allowed to make the response under the law. They are allowed to do that under 801. And so then we got to the court saying, we're not arguing this anymore. I'm just ruling. And then the defense started arguing, well, fine, if that's coming in, we want all of it coming in. And then they went round and round on if all of it's coming in for a while. And the prosecution's like, no. If you want to send all 900 pages back to the jury, send all 900 pages back. But we're not publishing to the jury all 900 pages or all 7 hours of testimony. We're not doing that. We don't have to do that. We're not going to do that. And so then back round and round again about what was going to be admitted and how it was going to be presented to the jury. Then we got to the court ruling that what the prosecution has submitted is coming in. The judge does not want to send the transcripts back and ask the prosecution if they can edit it. Then the defense said, well, if that's your ruling, we need a 2-day continuance, because the court in the ruling said the defense has not provided sufficient specificity on where they want to essentially embiggen the statements for completeness. The defense just kept saying, all. We want all of it. All. The court's like, you did not provide me any specificity. So we're admitting what the prosecution has asked for. And that's done. The defense is like, no, I want 2 days. And the court's like, no. Denied. So the defense is like, what are you? 1 day. We want 1 day. And the court's like, till tomorrow morning. From now till tomorrow morning. And then the court took 5 minutes and narrowed that down to, y'all need to file, defense, you need to file a motion by 6 p.m. tonight, and you need to delineate exactly where you are asking for prior inconsistent statements and exactly where you are asking for 106 completeness statements. And the defense is like, we can't get all that done. The court's like, I don't understand what the problem is. These are transcripts that you've had for at least a year. This was one of the state's biggest witnesses, so you're aware. And you need to evaluate the statements that the state's putting in and the context around them. That's the biggest part of this. So no, you have till 6. Because then the prosecution needs to respond, the court needs to read it, and the court needs to rule on it. So then the prosecution can edit it sometime tomorrow. And a lot of you are asking, Emily, but what happens if they don't file it by 6? The prosecution is still going to get squished on having to get it edited. Yeah, the prosecution is going to have to eat it if the defense is slow, because the prosecution needs to get their witnesses done and move the case along in front of the jury. And the prosecution is the side that's going to bear that burden of having to get it done. And the court will be displeased, but I imagine the court won't do much else about it other than be displeased. I don't imagine that this judge on this issue will say, then you don't get any of your edits. I don't think the judge will do that, because that becomes an appellate issue. And so it will end up being a squish for the state. And the court will be displeased, but the court is not going to change the ruling in a way that could create an appellate issue on a key witness. What can the state do? The state can say, Your Honor, we need a little bit more time to edit the video. And the court says, fine, you can play the video at the end of the day then. Instead of now, somebody can work on it. The state can't appeal it. And if she's acquitted, the state can't appeal anything. And if she's convicted, the state can't appeal anything. I think that the court has been incredibly gracious with this defense team and has gone above and beyond at times to protect the record in this case. And the court has actually started pulling out more legal foundation from the defense. And the defense will say something and stop, and the court will add in, are you asking this, 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 and this to protect the record? And the court has gone above and beyond to assist in protecting the record in a way that I have not seen a lot of judges do. So are you saying you are asking for 106 rule of completeness, defense? And the defense is like, yes. It is frustrating to watch. I think this judge very much sees his role as protecting the rights of the defendant. And a lot of judges, at the end of the day, will err on the side of the defense in these particularly critical trial matters to protect the record. I am very curious. The way I'm going to be sitting here at 6 p.m. Mountain Time, just refresh. I'm going to wait till that thing hits the docket. I'm going to send you an app notification when that shit hits the docket. I want to see the fucking filing stamp. So the second that hits the docket, it's probably going to be redacted. But the second that hits the docket, I'm going to send you a push notification in the app because I want to know too. Oh, my petty ass is going to be sitting here refreshing to see when they file it. You bet I will. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.